Good morning, good afternoon, and good evening. Thank you for joining this event as part of the 2022 Data Privacy Day here at the World Bank Group. Welcome to the IFC MIGA conversation with Dr. Gabriela Zanfir Fortuna, the Vice President for Global Privacy at the Future of Privacy Forum. In this conversation, we'll discuss some of the latest trends in global privacy, including recent developments with respect to international data transfers and the challenges organizations face to keep a pace in this rapidly evolving area. We'll also look at the growing body of data protection laws and court rulings related to automated decision-making and how this impacts the increasing use of machine learning and AI applications. At this point, I'd like to turn it over to Kerry Lawley, Chief Compliance Officer at the IFC, for some opening remarks. Over to you, Kerry.
Thank you very much, Gero. So hello and a big warm welcome to another very interesting session at the World Bank Group's International Privacy Day of 2022. This is our third year hosting a Data Privacy Day event. And as we look forward to privacy trends and future developments, I thought I would pause and kick off this session by taking a look at the origins of Data Privacy Day. So Data Privacy Day commemorates the day when Convention 108 was opened for signature by the Council of Europe. This happened in Strasbourg in France on January the 28th, 1981. So probably a long time before many people attending today were born. Throughout the years since then, the convention has been either ratified or acceded to by 55 countries. So this includes all the members of the Council of Europe and a lot of non-EU countries such as Argentina, Mexico, Morocco, Tunisia, Uruguay, Capo Verde. And this highlights the importance that privacy was beginning to play around the world, even back in the 80s. Convention 108 is also significant because it was the first legally binding international instrument to address the need to protect personal data. It contained principles and it also highlighted the individual right to privacy. And the principles have laid the foundation of everything that's come since then, including developments such as GDPR, General Data Protection Regulation. So let's fast forward to 2018, when the convention was updated. It was updated to respond to challenges posed by new technologies, globalization, and increasing international data flows. And two major challenges were addressed in those 2018 changes, which are relevant today. The updates were relating to the rights for individuals in the algorithmic decision-making context, which, as we know, is very relevant to AI and machine learning. And the changes were also relevant to responsibilities and independence of data protection authorities. So with that context in mind, I'm delighted to be able to welcome Dr. Gabriela Zanfir Fortuna. She's going to discuss these challenges and other emerging privacy trends. Dr. Zanfir Fortuna is the Vice President for Global Privacy at the Future of Privacy Forum. In this role, she leads the forum's work on global privacy developments and EU data protection law. Today, we're very privileged because we're going to be one of the first audiences to discuss the forum's latest report on landmark judgments and decisions that have shaped how courts and data protection authorities are approaching automated decision-making and profiling. As we all know, these cases have created a new set of ethical and legal challenges. The session is co-hosted by IFC, that's the International Finance Corporation, the private sector arm of the World Bank Group, and MIGA, the Multilateral Investment Guarantee Agency, which is also another key institution within the World Bank Group. Jennifer Trotsko, IFC's Chief Data Privacy Officer, and Gero Verheyen, MIGA's Data Privacy Officer, will moderate. So, recognizing how far we have come since Convention 108 in 1981, I do hope you enjoy this very interesting discussion and many of the other Data Privacy Day events that are happening as the day ensues. So with that, I'm going to hand back to Gero and to Jennifer.
Thank you, Kerry, for those welcoming remarks, and welcome, Gabriela. Gabriela, tell us a little bit about the future of Privacy Forum. What was it established to do, and what are the main issues you're focusing on now in 2022?
Hello, Gero. Hello, everyone. Thank you so much for giving me the opportunity to address your distinguished audience today. Well, FPF is a think tank. It's a nonprofit organization based in Washington, D.C. that serves as a catalyst for privacy leadership and scholarship, advancing principled data practices in support of emerging technologies. That is a fancy way of saying that we really think technology brings, has the capacity, the ability to bring a lot of good in the world, but at the same time, we want to promote responsible data practices and think about safeguards that we can put in place so that the rights of individuals are protected while we enjoy advancements in technology. Well, the FPF has its headquarters in Washington, D.C. However, we also have three offices, one in Brussels, one in Tel Aviv in Israel, and the other one in Singapore, because we are seeing how data protection became a very big global topic. We are seeing developments that are interesting everywhere in the world, and we want to be close to these developments in order to understand them. I think also to address the second part of the question as to what we will be focusing in particular this year, we are doing work on automated decision-making, as was mentioned also in the introduction. My colleagues are working to understand immersive technologies. So we are including here everything from AR, VR, so augmented reality, virtual reality, to brain-computer interfaces, and all of this sort of next level of technology that we can already have a grasp of looking towards the future. We are spending a lot of time thinking about how all of these developments in how personal data is being collected and used have an impact on civil rights. This is a very big topic in the United States, but also in other jurisdictions where we're looking, and we want to understand better how this intersection happens. This is also very much linked to the automated decision-making part that I mentioned, and looking into how algorithms that are built and rely on personal data then have an impact on communities and on individuals in, frankly, all aspects of their lives at this point. So we are a busy bunch, I would say, and we're doing very interesting things. We're lucky to be able to spend time thinking about these things.
Thank you. If I can follow up on that, you're covering a lot of ground in this research, and so it would be very interesting to hear if at this point you're seeing any overarching trends that have become apparent.
Yes, absolutely. Well, we are seeing an increased focus on impact of technology and massive processing of personal data on civil rights, on fundamental rights, and just also communities in general, right? So this is something that we are seeing in all of the jurisdictions that we're looking at. There are some developments that are very interesting for those following the evolution of data protection laws from the 70s and the 80s, as we've heard, that when this field started to evolve and emerge. To give you an example of an interesting next step that I'm seeing in some of the laws that appear out there is a blurring of the lines between regulating personal data and non-personal data, right? It seems that all data starts to become very relevant when the processing capacity of computers significantly exploded. And in this sense, to give you an example, we are already seeing a next generation of data governance laws, primarily in the European Union right now, where a data governance act is very soon to be adopted that actually applies to both personal and non-personal data, and that creates an environment for data intermediaries to exist and function as entities that obtain data from organizations and then on mandates from data subjects, from individuals, move that data forward to other environments or other organizations. We will soon see a data act coming out of the European Union, as well as a legislative proposal. Now we're looking at an AI act in the European Union as well. Some of these new legislative initiatives take a holistic view over data. And they actually build on the very strong safeguards that the GDPR has put in place for personal data in particular. But that's not the only jurisdiction where this happens. Very recently in India, we've seen that in the long process to legislate the Personal Data Act, which started officially in 2019, we've seen a report, a progress report with amendments just 2 months ago, where the Personal Data Act title was actually changed into the Data Protection Act, right? No, actually, Personal Data Protection changed into Data Protection Act, because the intention is to have it apply to both personal and non-personal data with a different set of obligations. So this is something that's interesting. It's not immediately impactful. This is something, if you want to look in the next 3-5 years of where this field is evolving. So I will just leave you with this thought.
Thank you, Gabriela. Wonderful to see you again, and thanks so much for joining us for another session this year. My question to you is related to privacy in the pandemic. And I think we'd be remiss if we didn't ask you, from your perspective, how has COVID impacted the trends that you just described? And I will say that there is a session following this one on this very topic, but we would very much like to hear your perspective on that as well.
Thank you so much, Jennifer. And indeed, it's a great pleasure to share a conversation with you again this year. Well, the pandemic accelerated a lot of the ways in which we use technology, and accelerated data collection, accelerated also understanding of how important it is for a specific context such as public health to collect data and to share data and to have access to various data, how important I would say even sharing data across borders is, because I cannot imagine an effective clinical trial that does not collect information from many countries, right, and individuals from many countries. So in this sense, the pandemic pushed us a bit into the future, a bit quicker perhaps than we were ready. So it's interesting to see how now we had to think about things like privacy preserving contact tracing, right? And we had to look at solutions on decentralized contract tracing apps, and how we can use Bluetooth technologies to to ensure contact tracing, but at the same time preserve the privacy of individuals and not have them feel that their freedom is completely taken away and that they're constantly monitored wherever they go. So the pandemic created this framework for the conversations in this field where we need to accelerate a bit the safeguards that we think are effective. So I would say this is the main impact that the pandemic had. It's also interesting to see, for example, how data protection authorities and courts had to make some quick decisions on some interesting scenarios that were pushed by the pandemic. And I will give you an example from a case in Bulgaria where a school, like a secondary school, wanted to introduce automated facial recognition and automated scanning of temperatures at the entrance of the school so that they could not allow access for individuals that had sort of increased temperature than the normal medium. A court, well, actually the Data Protection Authority looked at that plan for the school and said it's unlawful and did not allow the school to move forward with such plans. So they wanted to do this, you know, to manage the pandemic, but then it was just breaching the right to personal data protection and the right to the protection of private life in a way that was considered unacceptable. Some of these decisions were also pushed by online proctoring and, you know, monitoring of students while they take exams. And we have a number of decisions in Europe, and I have two in mind, one in Portugal and one in Italy, from data protection authorities, but also from a court, saying that this online proctoring systems were very intrusive. They breached the right to private life of students, and they were deemed unlawful. The universities were required to stop using them. So the pandemic pushed a lot of this very fast in front of authorities, and they had to step up.
Fascinating, thank you. Really highlighting the tension between the need to address the pandemic and the privacy considerations, and that how that sometimes conflicts a lot of times. So back to you, Gero.
Thanks, Jennifer, and thank you, Gabriela. Gabriela, as you know, IFC and MIGA are international organizations that work with private sector clients, many of which are based in jurisdictions with new privacy regulations and legislations, and in fact, some are spread across multiple jurisdictions. Our work heavily relies on the collection and transfer of information to our respective organizations, including often personal data. Can you tell us about some of the latest developments related to international data transfers that we should have on our radar as international organizations? Thank you.
Absolutely, Gero. Thank you so much for this question. In fact, international data transfers is probably the most top of mind issue this year for privacy and data protection professionals. We've seen a big judgment in 2020 from the Court of Justice of the European Union that invalidated the transfer mechanism put in place by the United States and the European Union, the Privacy Shield, because the court found that the safeguards provided by the US legal framework for government accessing personal data made available from companies, from organizations, personal data of individuals living in the European Union, transferred to the United States, well, those safeguards were not sufficient to ensure an adequate level of protection to that in the European Union. Now, in the aftermath of this judgment, we are in a kind of a limbo place right now because the US government and the European Commission have not yet reached an agreement to replace that framework, to replace the Privacy Shield. And this brings a lot of legal uncertainty to all, frankly, all data processing that is being done by US-based entities and involves the personal data of persons living in Europe. That's one of the key developments, right? And it's certainly something that's top of mind for the privacy community, and we don't really know where it will go. And perhaps we can talk a bit in detail in the following sections about the sections of our conversation about this particular case. But I would say what's very relevant for our audience today is to know that with the GDPR, which was adopted in 2016, entered into force in 2018, the issue of international data transfers is not solely concerning transfers across borders between countries. The GDPR has a provision, the general transfers provision in Article 44, that says an adequate level of protection, an equivalent level of, essentially equivalent level of protection needs to be ensured when personal data travels from the European Union to countries outside of the European Union, but also to international organizations. So international organizations made their way into this type of provisions, starting with the GDPR. And now we are seeing such a reference being made in other general data protection laws that are adopted around the world. I will give you an example. For in Brazil, in the LGPD, which was adopted in 2020, or entered into force in 2020, we also have a similar provision saying that personal data of Brazilians, when transferred to third countries, will need to be transferred to third countries and international organizations that ensure a similar level of protection. And then, of course, there are different rules and there are some variations to the international data transfers regime in the European Union. We are seeing the same idea in this data protection bill that it's currently being discussed in India. It actually has a very strong draft provision, right? So this bill has not yet been adopted. It's currently under debate, which restricts sending sensitive information outside of India to third countries or international organizations as well. And sensitive information is defined in such a way that's quite broad, and it includes financial data of individuals. And then there are specific conditions that the bill sets out. So as you can see, in this new generation of data protection laws that appear after the GDPR, the idea that data transferred needs to be equivalently protected now also is relevant for transfers to international organizations, not only to third countries. But I would say for the time being, the regulatory community and everyone is just so much focused on the first part of this type of provisions, right? That we have not seen a lot of attention or debate around this. However, there is some work being done, and I would point folks to the work of Professor Christopher Kuhner in Brussels, who has spent some time thinking about these issues and international data transfers to international organizations.
Thank you, Gabriela. I think this, especially the last part about this international organizations becoming more prominent in the legislation as it's being developed, really highlights the urgency of institutions having their data privacy policies in place and operationalized. Ours became operational on February 1st of last year. And we know that a number of organizations are still working to really get the appropriate structures in place. Jennifer, over to you.
Yeah, thank you, Gero and Gabriela. Kerry alluded to in her opening remarks, she alluded to some new research that you've just published about how national courts and national data protection authorities have approached the sensitive issues surrounding automated decision-making and profiling. And just yesterday, last evening, I think, is when I caught a glimpse of it on LinkedIn, you published a detailed analysis of recent rulings by the European Data Protection Supervisor and the Austrian Data Protection Authority. Could you enlighten us? Tell us what you found.
Well, let me briefly address the second part of your question, because it's very much linked to the international data transfer conversation we just had. I will make a small parenthesis also, because I pointed everyone towards Professor Christopher Kunar in terms of thinking of data protection in international organizations. But I also want to say that the European Data Protection Supervisor in Brussels has been organizing for a number of years workshops for international organizations and how they can put in place a data protection program that actually will ensure transfers will continue to happen from private organizations and governments, right, to international organizations. So perhaps that's also something that this audience is interested in and can follow up later on. Now, on this particular recent decisions that we've seen from the EDPS, the European Data Protection Supervisor, and from the Austrian Data Protection Authority that I recently published a summary of, well, they are very significant, and they are a consequence of that big judgment I mentioned from July 2020, because they are technically applying the findings made in that judgment in specific cases, complaints that were submitted by an European NGO on behalf of individuals, and that actually target the use of Google Analytics cookies and other cookies like the Stripe cookie for for payments via websites, and the use of this particular cookies on websites ran by EU registered operators. Now, these decisions of the data protection authorities technically find that the use of the cookies involve processing of personal data. So the unique identification numbers in the cookies are considered to be personal data, even if the user of the website, the visitor of the website, is not really identified by name and other identification criteria. However, the GDPR only requires for an individual to be identifiable, or for the possibility for an individual to be singled out in order for the rules to apply and for the data to be considered personal. So the DPAs found there's personal data being processed, and because the entities that created the cookies and placed the cookies are actually based in the US, the DPAs took the position that there is a transfer of personal data occurring to the United States by the mere use of these cookies. And because the safeguards of the US legal framework around government access to personal data have been declared not proportional and in breach of the standard required by the EU, in that judgment, they said that the transfers are unlawful. And they technically said that the supplemental measures, so any other additional measures that organizations put on top of their standard contractual clauses for this particular transfer were not enough, because they were not able to close the gaps that exist in protection of personal data here in the US. So these are two decisions of DPAs that preface a series of 100 more decisions to come, because these complaints were submitted by the same NGO, NOIB, which is led by Max Schrems, the individual who was at the core of that big judgment in 2020. All of these 100 complaints use the same legal analysis and legal arguments. When they were submitted in parallel in August 2020. And now the DPAs are starting to issue their decisions. So we are expecting to see similar decisions in the upcoming months. There may be some variations, of course, because the facts of the case may vary here and there. Also, the DPAs have their independence, so they can rule according to their own practice. But at the same time, we also know that they have created a task force to talk to each other, because I think all of the data protection authorities in Europe received at least one of these complaints, and they wanted to coordinate their action a bit. So this is one of the big developments of this year that we are definitely closely following. In the meantime, the European Commission and the US government are still negotiating for a replacement of the Privacy Shield. There have been recent media reports that we might see an agreement before the summer. However, there have also been media reports last year that we might see an agreement before the end of the year, and we have not seen it by then. So that's the big story, I would say, of the beginning of the year in the privacy space. But it strictly involves personal data from transfers of personal data from the European Union to the United States. That's the primary subject there. Now, on the other part of your question, we have been indeed doing research throughout the last year, my team and I have to have a shout out here to Sebastião Barros Vale and Caterina Demetsu, my colleagues that have been researching these topics in detail throughout last year. So we've been looking at case law in the European Union where the GDPR was applied to many instances of automated decision-making in many fields and sectors of activity and slices of life even, because we found that the rules of the GDPR are broad enough to capture under the big hat of automated decision-making, facial recognition systems, algorithms used in the workplace, like for job applications, algorithms used to decide the creditworthiness and risks in this sector, in the financial banking sector as well. So absolutely a very broad impact that the General Data Protection Regulation and data protection law as a whole can have on algorithmic decision-making and automated decision-making systems. And we are already seeing this impact being manifested in case law in courts, but then also with data protection authorities. We have identified about 30 cases, but then also some additional instances where we only have guidance from data protection authorities in this sense. I would say perhaps before giving a couple of examples of these cases, that it's important to mention why the GDPR and data protection law are relevant for this type of cases. Well, first of all, the GDPR is meant to be a technologically neutral law, and this is actually specified in its one of its recitals. I believe it's recital 5. So there is no wonder that it can be applied to any technology, all and any technologies that involve the processing of personal data. And processing as a legal notion and personal data as the other legal notion are very broadly defined to cover any operation that's done on a data set, and that data set, if it involves personal data, the GDPR rules apply with all of their complexity. Lawful grounds for processing, the need of, for data protection impact assessments, the principles of fairness, minimization, and so on. And automated decision-making very often involves the processing of personal data when feeding the algorithms that are being used, right? So this is why the GDPR becomes relevant for this particular technological developments. Now, the GDPR also has a dedicated provision to automated decision-making, which is under Article 22, and which says that individuals have the right not to be subject to automated decision-making that's solely automated and that has a legal or significant effect upon the individual. This has been interpreted as a prohibition to engage in this type of automated decision-making by the data protection authorities. And well, then there are also, there's a set of rules though that, first of all, would allow exceptions from this prohibition. So for example, the exceptions are whether there is express specific consent of the individual for such a decision making to take place, or whether this type of solely automated decision making is necessary for a contract that the individual asks to enter into. However, even when these two conditions are met, on top, well, there's also the legal obligation. I mean, if such a decision-making system is imposed by a law that has enough safeguards, then that's also permissible. However, what's relevant here is also that even when such consent exists, or even when the contract condition is met, this solely automated decision-making system also has to comply with 3 requirements, very important. There needs to be some human intervention that is taking place. There needs to be, the individual needs to have the right to be heard, the right to express their point of view with regard to the decision. And also the individual needs to be offered the possibility to contest the decision. So there is certainly a level of complexity in order to engage in this type of automated decision-making. Now, courts and DPAs are starting to spend a lot of time in thinking about what is solely automated decision-making, right? What degree of human involvement in that loop of automated decision-making is enough to consider that such a system is not solely automated. We have actually seen cases where even if a human was mentioned there as doing something, the courts and the DPAs have looked at exactly what that human was supposed to do and what level of decision-making it had to ascertain that it's just not masking a solely automated decision-making. So the intervention of the individual needs to be more than a token intervention. And I'll go back to the case with the online proctoring in Portugal that we've seen. That the university that was planning to use one of the systems of online proctoring had a procedure, had sort of an individual assigned to rubber stamp, as the as the DPA found, instances where students were seen or were believed to inspire themselves from other sources than their own knowledge, right? But the individual did not really have to talk to the students and did not have to assess the entire situation. The individual was just there to say okay to whatever the system was telling him to do. And the DPA found that this was not real human involvement, and therefore we are having a solely automated decision making system in place. And then all of the other conditions that I mentioned with, well, the GDPR, because Article 22 was not applying, this was not, oh no, actually all of the other conditions in Article 22, yes, because this was considered solely automated, were not met, so therefore the entire system was deemed unlawful. At the other end of the spectrum, we've seen a decision in the Netherlands on automated screening of individuals that apply for gun licensing in the Netherlands. Apparently, you know, that's also a thing in the Netherlands, right? Not only here in the US. So for this particular case, the court in the Netherlands found that because the automated screening resulted into a recommendation that was then assessed by an office of the police, and then it had to be approved by the chief of that police particular unit after reviewing it. It found that this was not solely automated decision-making because there was a process that was well-defined, and the roles of the individuals involved were also well-defined, and the individuals were instructed when to take into account the result from the automated screening and when to not take it into account. So therefore, in this case, the court found that it's not solely automated decision-making. So therefore, all of the extra safeguards in Article 22 are not needed. However, of course, the rest of the GDPR applies. So you still need to inform the individuals about how the processing is going on and so on. I can talk about these cases for the whole day, and I realize that we don't have the whole day. So I will stop now.
Well, that it's just fascinating to listen to you. You're just a wealth of information. So thank you so much. I do have a follow-up though. There's a lot there, but I want to focus a little bit on the role of the DPAs. And, you know, do you think because of these recent cases that you mentioned earlier, that their role is changing, and how do you see their role, you know, evolving in the future? And then, you know, a corollary to that is, we have a question from the audience actually, which is how can countries that do not have a well-established data protection authority hold technology companies accountable? So how are they, those situations interacting with all the new technologies that are emerging?
Those are wonderful questions, and they really go to the crux of what the right to data protection is conceptually, and how it was defined, well, at least in the European Union, where we have it in the EU Charter. Because maybe this is not broadly known, but as the EU Charter of Fundamental Rights provides for the right to personal data protection in Article 8, distinct from the right to respect for private life in Article 7, it actually includes the existence of an independent supervisory authority in paragraph 3 as a component of this fundamental right. So from the beginning, it was thought that the idea of an independent authority, independent from the executive, right, independent supervisory authority, is needed in order to guarantee this right to personal data protection. So the role of data protection authorities is absolutely essential if we want these rules and this system of rules to actually work in practice. Now, their role has increased and their job becomes ever more complex because the technologies that process personal data become ever more complex. At least in the European Union, what we're seeing is that it's actually possible in the coming years to see data protection authorities gaining competence in the application of the future AI Act as well. I would have to say from this point of view, as you can tell from the cases that they already deal with, right? We expect to see overlap between at least facial recognition, but a lot more, and how data protection law applies to them, and then overlap with some of the provisions that the European Union is considering on the AI Act. And then I think it's very important to understand at this stage of the lawmaking on the AI Act where this overlap exists, and to understand how data protection law already deals with a lot of this technology. So the role of DPAs might increase even more. I think there are a lot of expectations on the shoulders of data protection authorities with the enforcement and application of the GDPR. We also hear complaints from, particularly from data subjects and the civil society, saying that they would like to see more enforcement. Sometimes we hear complaints from companies saying that data protection authorities are too strict in their interpretation of the law, like with the Google Analytics cases that I just mentioned. So they're a bit in between a hard and a rock, a rock and a hard place. And, but this shows how important their role is and how their role will increase. And this also shows why it's important that wherever this legal framework makes its way in the world, it's important that it comes with a specialized authority that applies the rules. And then, of course, in each legal system, this authority can absolutely have a different face, let's say, and it has to be an authority that makes sense in that jurisdiction and in that legal system, right? But I really believe that a specialized supervisory authority is needed to be able to enforce data protection laws.
Thank you. Gero, do you have another question? Like Gabriela,
yeah.
Catch your breath.
I do have another question, and your emphasis just now on regulators in the legal systems. This is a very quickly evolving field, not only in terms of the appearance of regulations, and as you mentioned in India and in the EU now, with the broadening interpretation of not just personal data, but data as a whole. Do you think that the judiciary in these countries is keeping a pace? Do they have the adequate knowledge and background to understand these concepts and the ability to keep up with this as they're adjudicating some very nuanced issues here?
Wow, that is a truly wonderful question, Gero. Thank you for that. And it has a very short answer, but I will expand on it, because the answer is no. I don't think they are well equipped to understand the complexity of the technologies that are involved here, first of all. And second of all, traditionally, data protection law was not really something that was taught in law school, right? As a lot of the judges were being trained, at least not even in the European Union, and I'm saying that because, as we know, the European Union started to adopt these laws in the early 70s, and then they kept evolving. So there is certainly a gap there, and this gap is starting actually to be smaller and smaller, as so many cases right now reach courts, and then judges have to learn quickly, how to think about these technologies, and then how to interpret data protection law in a way that applies effectively to protect individuals, and to uphold the rule of law. They're kind of recuperating, I would say. They're making up for the time lost in the past. And I think it's absolutely needed because, of course, data protection authorities are like public administration authorities, right? So they don't have an ultimate power to decide upon things. Like, their decisions are always subject to judicial review, as it should be, because we're speaking of rule of law here. But this means also that judges and that entire court system needs to quickly get up to speed with all of these developments, and hopefully we'll see more of that in the coming years.
In the piece that you published yesterday, you mentioned that the Austrian NGO had filed these cases, I think 101 in total, in 27 countries. And if I recall correctly from your piece, about half of those were in Austria. So I would think that presents a tremendous learning opportunity for the Austrian judiciary if they look at those one at a time, or if it's looked at collectively. But it's I think we're going to probably see more and more of this as awareness also grows on this subject in the broader public. And with that, Jennifer, do you have one more question for Gabriela?
Yeah, just one more question, Gabriela. And this one might be a little more philosophical. So a lot of the overarching themes that you spoke to today point to AI and machine learning and algorithms. What are some of the most noteworthy ethical challenges that you're seeing, and how can data protection help in navigating those challenges? I mean, this is maybe a big question, but if you could just give us some thoughts on that, that would be super.
This is indeed a very big question, and I have to say I'm not well equipped to deal with ethical questions and the ethics involved in automated decision making and in applying AI systems. I like to focus on the legal requirements, right, and try to think about these things from the legal point of view, and applying the rules of data protection law to these systems. But without making this about ethics, and I don't want to step into a field that I'm not really very good at or familiar with, I would have to say that one of the key challenges I see from the legal data protection perspective with these systems is that they have an impact not only on individuals, but also on community and society. And data protection law, when was being created, was focused very much on individual rights on paper. Now, I believe that to the extent data protection law is procedural and it actually is a means to obtain compliance with fundamental rights generally and the whole array of fundamental rights, I think there is room to apply it to also protect community interests as well, and protect classes of vulnerable people, for example. but we just need to interpret it that way, right? And we need to create the framework that it should be applied that way.
Interesting. Thank you. Thank you. Gero?
I think given where we are in this very interesting discussion, I think if we ask Gabriela another question, then we're going to go well past the allotted hour that we have for this event today. So at this point, I think, Gabriela, thank you. And I would invite Aradhana Kumar-Capoor, who is Director and General Counsel at MIGA, to offer some closing remarks. Over to you, Aradhana.
Thank you very much, Gero. Gabriela, thank you so much for this very engaging discussion. Really, we learned so much today. As you pointed out, the concepts of data privacy are evolving at a very rapid pace. This not only manifests itself in the growing number of privacy regulations around the world, but also in the manner in which data more broadly is being viewed and governed. As private sector-facing institutions which collect and process significant amounts of data, including personal data, we must take care to protect this information in a manner that provides our clients with the confidence that they need to do business with us. Having said that, and having heard what you had to say today, what is clear is that a privacy policy by itself is not enough. We must keep a base of the developments in the privacy sphere so that we're always aware of the challenges our clients face when they collect and transfer this data to us. And more importantly, we need to cultivate a privacy culture at our institutions. You told us today about some overarching trends, the increased focus on the impact of technology and privacy on civil rights, a fascinating topic by itself. You also highlighted the blurring of lines in legislation between data protection laws for personal data and data in general. And then you discussed about, of course, the most important thing that we're all dealing with, the complication of the pandemic, which has accelerated the use of technology and data collection even across borders. And then we discussed, we highlighted or learned a little bit about how judiciary needs to keep up with these changes, the ever-changing scenario. We learned about the recent decision of the European Data Protection Supervisor and the Austrian Data Protection Authority regarding the collection of information by Google Analytics and Stripe. In addition to the trade and economic implications, these cases and the 100 other cases still with courts raised important questions about information collection and the greater need for governance and regulation to help ensure that data privacy is respected by corporations as well as governments. These decisions also underscore the importance of data hosts and providers, ensuring that the documentation and safeguards they put in place are in fact sufficient. As AI and machine learning continue to develop and become integrated in the way we work and interact, it is clear that this technology can be of tremendous benefit to society. It has also become clear that without proper governance, it can pose significant risk to individuals and to society as a whole. Gabriela, your insights today, and in particular, the thoughts you shared on your most recent research have been very informative. It will be most interesting to see how the data privacy landscape develops as more of these cases in Europe are decided, and to what extent privacy regulations will be refined to take these decisions into account. Now, let me also thank Gero and Jennifer for moderating this panel so effectively. And let me now hand over back to Jennifer.
Thank you, Aradhana. As we wrap up for today, I just want to give a big thanks to Gabriela. I mean, it's true, we could just talk for hours about these things. And, I hope one of these days we can do it in person over a cup of coffee. So we look forward to that day. But thank you again. And thanks to my co-host Gero and to Kerry and Aradhana for some insightful opening and closing remarks. Next up on our agenda today is a session at 11:30 on privacy and the pandemic. And I do hope that the audience will tune in to that one, as well as to the others throughout the afternoon. And with that, Gero, I think we'll just wrap things up for this session. Anything to add? Okay, super. Again, thanks to everybody, and have a great afternoon and enjoy this really exciting lineup we have for you today. Thank you.